the capital, Nairobi, and Wajir Governor Mohamed Abdi will know his fate today when the Court of Appeal decides on his case against the High Court's decision to nullify his election. Abdi's election was nullified by Justice Alfred Mabeya on January 12th on the grounds that the election had not been conducted according to the law and that his academic papers were not proper. But in his appeal through Senior Counsel Fred Ngatia, Abdi argued that Justice Mabeya misunderstood the law and had bypassed key evidence when invalidating his election. Let me now take you straight to the Court of Appeal where that proceeding is going on now. And we're going to get those live pictures shortly for you. We're getting reports that the current governor has not yet shown up there. But at the moment, the former governor, Ahmed Abdullahi, is in attendance together with PDR gubernatorial candidate Ahmed Mohamed. Those are some of the live proceedings from the Court of Appeal there. Let's now listen into that.
Could not have been eligible to enroll in any university, for he had neither sat for O-level or A-level examinations that would have enabled him to do so. 13, the petitioners aver that by the 3rd September 2014, the first respondent had not acquired a degree, a fact that he admitted during his vetting for the position of ambassador of Riyadh, Saudi Arabia, before the Parliamentary Departmental Committee on Defense and Foreign Relations that took place on 3rd of September 2014. 20, the petitioners state that it follows, therefore, that the concealment, alteration, and falsification of any relevant information by a candidate filling the self-declaration form is unethical and bespeaks lack of integrity on the part of the concerned. 21, the petitioners aver that the first respondent was constitutionally or statutorily disqualified from contesting for the election of Governor Wajir County as demonstrated below. 22, the petitioners further aver that the first respondent does not satisfy the educational requirements for qualification for the position of governor. 23, the petitioners aver that the first respondent, while filling the self-declaration form, concealed, altered, and falsified information on his educational background. Then 27, the petitioners state that a statutorily disqualified candidate cannot be validly elected to a state or public office. 28, the petitioners aver that the constitutional and statutorily disqualified, the petitioners aver that the constitutional and disqualification of the first respondent to contest elections means that his nomination as candidate and subsequent election was invalid, illegal, null, and void. 29, the petitioners state that the illegality to clear the first respondent by the third respondent to contest the gubernatorial elections was a direct breach of the Constitution and the law. And lastly, 30, the petitioners aver that the election of the first respondent was unlawful and ought to be invalidated by this honorable court of courts. In his affidavit supporting the motion, the second respondent addressed the issue of the apparent alleged non-qualification under Section 22 of the Election Act in paragraph 13 to 21 as follows. 13, that I have been advised by my advocates on record, which advice I very believe to be true, that Honorable Mohamed Abdi Mohamed, the first respondent herein, stood constitutionally disqualified to contest the elections, and thus his election was null and void. 14, that I have been advised by my advocates on record, which advice I very believe to be true, that Honorable Mohamed Abdi Mohamed, the first respondent herein, did not satisfy the requirements of Section 22(2) of the Elections Act 2012. 15, that I have been advised by my advocate on record, which advice I very believe to be true, that Honorable Mohamed Abdi Mohamed, the first respondent, herein purportedly presented misleading information to the Independent Electoral Commission to be cleared as a candidate for governor position, Wajir County Code 008, in the just concluded general elections of 8th August 2017, we showed that he had acquired a degree from Kampala University during the graduation ceremony of 1st March 2012, which he knew was untrue. Attached herewith and marked AMMA5 is a copy of the degree certificate that Honorable Mohamed Abdi Mohamed presented to the Independent Electoral and Boundaries Commission for clearance to run as Wajir Governor. 16, that I am seized of the fact that Honorable Mohamed Abdi Mohamud's name is not among the graduates from Bachelor of Business Administration, as can be noted from the 1st March 2012 9th graduation book, Kampala University. Attached here with and marked AMMA6 is a copy of the 1st March 2012 9th graduation book, Kampala University. 17, that I have been advised by my advocates on record, which advice I very believe to be true, that it takes at least 4 years to 6 years to acquire and or graduate with a degree. 18, that I have been advised by my advocates on record, which advice I very believe to be true, that Honorable Mohamed Abdi Mohamud, the first respondent herein, could not have been eligible to enroll in any university, for he had neither sat for O-level nor A-level examinations that would have enabled him to do so. 19, that I'm aware that by that September 2014, Honorable Mohamed Abdi Mohamud had not acquired a degree, a fact that he admitted during his vetting for the position of ambassador to Riyadh, Saudi Arabia, before the Departmental Committee on Defense and Foreign Affairs that took place in the mini chamber, County Hall, at 9 a.m. Nairobi. Attached herewith and marked AMMA 7 is a copy of the answer put-out with minutes and proceedings of the vetting department showing the declared results. 20, that I have been advised by my advocate on record, which advice I very believe to be true, that the conduct of Honorable Mohamed Abdi Mohamud in 13 above amounts to fraud and can only pass for an election offense, which is punishable in law and should be totally discouraged. And 21, that I have been advised by my advocates on record, which advice I very believe to be true, that contention, this is a direct quote, Mohamed Abdi Mohamud is not fit to occupy the said office, end of quote. The various documents referred to were duly annexed. When served with the petition, the applicant did not file a response to petition as required under Rule 11.1 of the Election Petition Rules 2017. He did, however, file a replying affidavit sworn on 1st September 2017, which the learned judge who heard the petition, that is Mabeya J., treated as the applicant's response to the petition. To those allegations touching on his education qualification to vie for the post of governor, the applicant's remarkably brief reply was as follows, quote, A, disqualification under Section 22.2 of the Elections Act 2012. 3, the petitioners are trying to mislead this honorable court as the issue of my educational requirements was litigated upon and decided by the Uganda High Court, where the said complaint was dismissed. Attached herewith, please find a copy of the pleadings that were filed in the High Court at Uganda in respect of the first respondent's degree certificate, being a chamber summons and supporting affidavit, a notice of motion and supporting affidavit, a summary of evidence, and an affidavit by the Rio Abdirahim Mohamed Abdire, where he denounced having filed the suit, a copy of the order issued dismissing the matter, and copies of my academic certificates marked MAM1. 4, that the petitioners equally raised the same concern with the third respondent, but the same was dismissed. Attached herewith, please find a copy of the complaint at the IEBC and the decision marked MAM2. 5, the petitioners are now trying to raise pre-nomination issues which have been determined, end of quotes. The appellant's 21-page affidavit did address the rest of the allegations in the petition at greater length, denying them and concluding that the petition was devoid of merit and good only for dismissal. On their part, the returning officer and the IBC filed a joint response to the petition dated 18 September 2017, in which they gave detailed responses to the allegations contained in the petition. They prayed that the High Court determined that the appellant was duly elected and that they conducted the Wajir gubernatorial elections in compliance with the Constitution and the electoral laws. They sought the petition's dismissal. Their position was evidentially backed by the supporting affidavit of the returning officer sworn on 18 September 2018. Witness statements were filed by the parties and pretrial preliminaries, including a consent entered into at the pretrial conference held on 9th October 2017 to the effect that documents were to be admitted in evidence without the requirement of strict proof. The matter thereafter proceeded to trial before the learned judge with a total of 18 witnesses testifying. Significantly, the appellant did not appear to testify in his own defense against the allegations leveled against him in the petition and be cross-examined on his replying affidavit. The learned judge adopted the issue for determination that had been agreed on by the parties, namely, whether the gubernatorial elections for Wajir County held on 8th August 2017 was in accordance with the Constitution and electoral laws. B, whether there were any electoral malpractices and offenses during the Wajir County gubernatorial elections held on 8th August 2017, which affected the outcome of the gubernatorial election. C, whether the first respondent was lawfully qualified to vie for the Wajir County gubernatorial election on 8th August 2017, and lastly, who should bear the cost of the petition and what should be the instruction fee on the petition. By the judgment dated and delivered on 12th January 2018, the learned judge made the following findings on the petition. Combining the first and second issues on the manner in which the gubernatorial election was held, and to answer the question whether it was constitutionally and legally compliant or fraught with malpractices and irregularities that affected the outcome, he found, one, there was irregular and procedural assisted voting which seriously compromised the principle of secrecy of the ballot. Next, there was no proof that there were instances where the total number of votes cast exceeded the registered voters on the identified polling station. Next, due to lack of training, some of the presiding officers exhibited sheer incompetence, with some failing to sign statutory forms, failing to countersign alterations, some sealing all the results in the ballot boxes and the like. The IEBC's officers were supplied with faulty equipment which affected the accuracy and efficiency of the election. Next, there were discrepancies and inaccuracies in the number of votes cast reviewed in the scrutiny report, but did not reveal a systematic scheme or pattern, and abnormal high votes turnout was not approved. Violence and intimidation was not proved. The returning officers acted ultra vires by taking over the process of vote tallying and declaration of Wajir East Tallying Center, but this did not affect the results of the election. Ballot boxes previously sealed at the polling station were irregularly opened, which interfered with the integrity and credibility of results at 2 polling stations. There was failure to properly transmit the results electronically to both the constituency and county tallying centers, but there was no evidence to show that the failure affected the results. Allegations of voter bribery by representatives of the appellant failed in limine. Alleged ejection of the first and second respondents' agents from the polling station was not proved. On the issue whether the appellant was lawfully qualified for Wajir gubernatorial seat, the learned judge held as follows. The High Court and the jurisdiction to determine the question of the appellant's qualification to be nominated as a candidate as an election does not refer to the single event that occurs on the voting day, but to the entire process of electing leaders, commencing from registration of voters up to the declaration of results. Next, the fact that the IEBC and the responsibility of determining the candidate's eligibility to vie did not preclude the election court from satisfying itself that a candidate was eligible to stand. Next, the appellant did not specifically or generally deny the allegations as to his qualifications, content to only state that the matter had been litigated and dismissed at the High Court in Uganda. He also did not earn up to be cross-examined on his affidavit, leaving the first and second respondents' evidence uncontroverted. As at that September 2014, the applicant had not yet graduated with any degree, and it is impossible that he could have obtained a master's degree 6 months later on 12 March 2015. Accordingly, as at 8 August 2017, the applicant did not have the academic qualifications for the position of governor, and he was not legally cleared to vie for it, as he did not satisfy the requirements of Section 22(2) of the Elections Act. Finally, on the question whether the applicant was validly elected as governor of Wajir County, the learned judge, after setting out the findings we have cited, held that the election was not conducted in accordance with the Constitution and the law, and that the proven irregularities were so grave that they affected both the credibility and the result that no reasonable tribunal could uphold the election. The applicant was thus not validly elected. With those findings, the learned judge concluded his judgment with orders that the applicant, the IEBC, and the returning officer Ndupi caused first and second respondents the instructing fee whereof he capped at Kenya shillings 2 million. He then made the following final declaration, quote, A, the first respondent was not validly cleared to vie for the seat of governor for Wajir County, as he did not possess the education qualifications. B, the first respondent was not validly elected to the position of governor, and his election is hereby declared null and void. The third respondent do hold Act 2011, and lastly, the respondents pay costs to the petitioners to be taxed by the Deputy Registrar, provided, however, that the instruction fee is capped at Kenya shillings 2 million. The appellant was aggrieved by that decision and preferred this appeal. The memorandum of appeal raises 5 grounds of complaint against the judgment, which are that 1, the trial judge erred in law by assuming and reopening matters that were and or should have been dealt with at the nomination stage, namely whether the applicant had been awarded a recognized degree by Kampala University. 2, the learned judge erred in fact and in law by not appreciating sufficiently or at all that the first and second respondents were obliged in law to prove their accusations against the applicant. 3, the learned judge erred in fact and law in not holding that the applicant was validly nominated to contest the position of governor, Wajir County. And 4, the trial judge erred in fact and law in not appreciating sufficiently or at all that the clerical irregularities, if any, did not, 1, affect the outcome of the election, and 2, confer any numerical advantage to the applicant. And lastly, the trial judge erred in fact and law in holding that the applicant was not validly elected to the position of governor, Wajir County. It is immediately noteworthy that, with the exception of the first, all the grounds of appeal purport to raise issues of fact and law in clear contravention of the jurisdictional bar imposed by Section 85A of the Elections Act, which expressly stipulates that appeals to this court in election matters shall be limited to questions of law only. It was thus no surprise that the first and second respondents, by their notice of motion dated 6 February 2018 and brought under the said provisions, as well as through 19.1 of the elections of the Court of Appeal Elections Petition Rules 2017 and 86 of the Court of Appeal Rules, made the following prayers: that this court be pleased to adhere by dialects at grounds 2, 3, 4, and 5 of the Memorandum of Appeal dated at 1st January be struck out for contravening Section 85A of the Elections Act. 3, that in any event the Court of Appeal completely lacks jurisdiction to inquire into the matters and or complaints set out in grounds 2, 3, 4, and 5 of the Memorandum of Appeal dated 31st January 2018. Cognizant that appeals in electoral matters are strictly time-bound and must be concluded and determined within 6 months of filing, this court directed that the motion be urged together with the appeal proper so as to economize on scant judicial time. Further directions were given for the filing and exchange of written submissions, as well as lists and bundles of authorities in readiness for the oral highlights of those At the hearing of the appeal, learned counsel who appeared were Mr. Ngatia with Mr. Macharia for the appellant, Mr. Menasil, Senior Counsel with Mr. Umbati, Jesse Oduo, and Brian Onderi for the first and second respondents, and finally, Mrs. Kamau Karori, Mahat and Ken Mary for returning officer and the IEBC. In urging the appeal, Mr. Ngatia gave a summary of the pleadings and prosecution as we have already out. He pointed out that at the outset that the appellant's election was nullified on the broad ground of not having been and the various irregularities on voting day that were found by the judge. In counsel's view, the case against the appellant was pleaded in the petition. In counsel's view, the case against the appellant, as pleaded in the petition, was that he had fraudulently acquired or forged the degree certificates he presented to the IBC. He went on to say that the appellant's answer to those allegations was that he was awarded a degree by Kampala University in Uganda and a challenge to it by way of judicial review before the High Court in Uganda by one Abdirahim Mohamed Abdi, being miscellaneous cause number 200 of 2007 filed against the university, and the appellant was dismissed. The reason for the dismissal was that the applicant therein had never instructed the law firm of Ms. Kandia Advocates to file the said cause. Counsel contended academic transcripts from the university had not been challenged, nor had his second degree, a master's in diplomacy and international relations, awarded by the same university on 12 March 2015, been challenged in Kenya. Turning to the merits of the appeal, Mr. Ngatia argued that as the issue of the authenticity of the degree certificate remains holding that a prima facie case had been made out by the first and second respondents, and he used the standard to hold that they had proved their case when he ought to have used the standard of beyond reasonable doubt, given that the allegations of a criminal or quasi-criminal character, namely fraud and forgery, had been made against the appellant. He further faulted the learned judge for taking the minutes of the Parliamentary Committee for Defense and International Relations as conclusive that the ones he is yet to graduate in relation to the...
It is exactly 46 minutes past the hour. Stay with us. We're going to return you back to the Court of Appeal shortly, where we do expect a final ruling by the court there with regards to the Wajir gubernatorial election. Remember that the current governor, that is Mohamed Abdi, had said that the judgment by the High Court was controversial. He was the first county chief to lose his seat following a petition filed by former Governor Ahmed Abdullahi, who is also at this moment at the Milimani Law Courts awaiting that ruling by the